For those of you who are joining us, while we're waiting for the rest to come along and get into the join us on the webinar, thank you for taking the time to join us today. Timing is actually really very relevant with this topic, and the fact that tomorrow we're going into stage 3 with the province and opening up virtually completely, although still with a lot of regulations in place. And of course, along with that, in the opening and people going back to work, and I understand that one of the big banks was back in the towers just a week or two ago, and starting to deal with filling up the downtown towers and dealing with elevators and people on the subway and in the transit, comes along a lot of questions about how, as business managers, owners, employees, how do we all deal with this, and how do we help keep each other safe and work through all of the issues, especially as the government changes the regulations. And I suspect that over the next few weeks, we'll see even more changes come along. Hopefully, as the rates of infection drop, we'll see more in the way of openings. So without further ado, let's get started because we do have lots of topics to cover. Again, thanks for joining us today. Our topic is navigating employment law in the COVID-19 era. And we will be talking about vaccinations and working from home, returning to the workplace, and how to deal with those policies, both from an employer, mostly from an employer, but certainly from an employee point of view. This webinar has been brought to you by Minken Employment Lawyers, and on our panel today, we have Ron Minken, founder and managing principal. He is the, as I said, founding managing principal, and has established the business in 1990. Known as the leader in the field of employment law and related litigation throughout Canada. Thank you for joining us today, Ron. Also on the panel, we have Kyle Burgess, who's a senior employment lawyer. Kyle has experienced and represents employers in a wide range of employment law matters, including terminations, wrongful and constructive dismissals, human rights issues, employment agreements, and policies. Welcome, Kyle, to the table today. And finally, Tanya Sambi, who's an employment lawyer. Tanya advises employers on their rights and obligations with respect to a wide range of employment law matters and provides strategic advice and guidance with respect to employment agreements and policies. So I'm going to turn things over to Ron, who will get things started. Thank you all for being with us today. Let's get into our topic.
Great. Thank you so much, Richard. And it's a real pleasure to have inviting us to speak on this really interesting topic. So my first one that I will be talking about is, can employees be required to vaccinate? Now, a bit of a disclaimer. Today, we're going to talk about legal issues. We are not suggesting that employers should mandate vaccinations or not mandate vaccinations or do anything at this stage. Every workplace is different. Legal advice must be obtained prior to taking any steps. So today, really, we'll be providing to you general information and not legal advice. So why ask, can employees be required to vaccinate? Well, we've had a lot of people contact us, small, mid-sized, large businesses, associations, asking us this very question. And the short of it is likely not to, can employees be required to vaccinate? So we thought we'd start by saying that. But we must look at the legal considerations. So there is no case law on this topic. So it's a new area. We look at comparative case law, such as, let's say, drug testing. Now that's a bit different because with drug testing, you're extracting something from the system. You're not injecting in the system. And that's rarely upheld only where there are serious safety concerns that are at play. We have some COVID-19 testing cases. And again, that's extracting, not injecting. And it's been upheld in a nursing home environment. Then flu vaccination cases, where these are injections, and it's usually not upheld because there are other alternatives to vaccines that are available. So from a legal perspective, you think of it, the COVID-19 vaccination. What is that? That's an injection of fluid into the body. It's more intrusive and potentially harmful rather than an extraction. So obviously, it's more difficult for an employer to establish a requirement to do so. So one looks at, is there a bona fide occupational requirement? And one looks at that and to analyze it, and then where can that be? Perhaps a hospital, a health care situation, long-term care place, emergency first responders, or perhaps a customer high service contact. So, there's an example where, we have to look at whether it is a bona fide occupational requirement. And then the overall most important thing is the Occupational Health and Safety Act, Section 25, sub 2, sub H. The employer shall take every precaution reasonable in the circumstances for the protection of a worker. So what's every precaution? What's reasonable? What are the circumstances? And what's the protection? That is the analysis that you'll need to have with your employment lawyer to determine what you can do and what you can't do. So at the end, the key thing is the Occupational Health and Safety Act. I did just get a news alert, and I see it's from the CBC. Ontario health workers could skip COVID-19 vaccinations under policy drafted for Ford government. Policy recommended to Ford government stop short of mandating healthcare workers to be vaccinated. So interesting. And here it says, although the document frequently refers to mandatory vaccination, the policy ultimately recommends would not actually require any workers to be vaccinated against COVID-19. It would allow unvaccinated healthcare workers to have contact with patients, provided that they wear full protective equipment, PPE, and undergo frequent screening for the coronavirus. So read this, it's just come in on this news alert. So that's a consideration we're going to have to look at as well. Now, steps to implement a mandatory policy. If it can be required, you got to first of all determine whether it can in the bona fide occupation requirement. It would be in your employment agreement, your policies. How do you handle future employees? What if they're different from current employees? Those are things to look at. Policies must be reasonable. If they're not, if you just want to put in what you want to put in because you're adamant that everyone should be vaccinated, and it's not reasonable, then it's not going to be upheld. You need to also in every policy include accommodation, such as PPE, working from home, social distancing, face masks, things like that, and also clearly communicate it to the employees. So what if an employee refuses the vaccine on the basis of a human rights ground or anxiety? Well, you'll likely have a duty to accommodate. So here, what are areas of human rights? Perhaps disability, mental distress, autoimmune deficiency, maybe age, perhaps, religion, depending on the ingredients and all these other things that are looked at. So there's a duty to accommodate up to undue hardship. So what form of accommodation? It could be, again, the wearing of masks, social distancing, and you must examine the whether undue hardship, because then you don't need to accommodate. So, but if you fail to accommodate and you gotta, that's a breach of the Human Rights Code. And we're looking at some very high damage awards in the last number of years at the Human Rights Tribunal. So you gotta differentiate between your everyday worries or disability. Did I forget to lock the door? Or was it a sense of impending doom where you're sweating, or your workers are sweating, difficulty breathing, being perhaps a psychological response to their worried thoughts. So you got to use your due diligence, get a doctor's note, you've got a right to question the doctor's note, and everything checks out, and there is a disability, well, or they have a grounds to claim that under the Human Rights Code to not vaccinate, then you have to accommodate. So what's undue hardship? Well, it depends on the situation, and each and everyone does in this situation. So if the employee is, number one, unable to perform any of their job duties that have been vaccinated, and it would be not possible to move them to another position, then that may be considered undue hardship. Sounds like a tough hurdle to reach. It is. If there is, and they refuse to vaccinate, then you have that option of terminating. You'd always want to get legal advice from an employment lawyer on this. It's a very, very tricky area. Then can you require an employee to get a particular vaccine? The answer is doubtful. You got to consider why. What's the legitimate reason for the requirement? So it depends on whether the policy is in place as well too. Now, what's the scenario? Maybe a certain vaccine is shown to be more effective against another vaccine. So you need to get your data as an employer, get your evidence out to be prepared to justify when the employee says why. Of course, you want to communicate the reason, and you want to have all your data, all your evidence before you to justify to your employee. The way it's looking now, unless you can get that evidence that one is better than another in a certain situation or a certain workplace, then likely not you can't require them to take a particular vaccine. So we've covered those. Now another interesting topic, and Kyle Burgess will be doing this one, and it's what if an employee gets sick from the mandatory vaccine?
Thanks, Ron. Hello, everyone. Good afternoon. I still haven't gotten used to this, not seeing people I'm presenting to, but I know you're all there. Thank you for joining us today. So as Ron said, what if there is a mandatory vaccine, and what if an employee gets sick from this mandatory vaccine? Typically, if a company is insured under the Workplace Safety and Insurance Act, then the company can rely on the Workplace Safety and Insurance Board to pay for any injuries that are sustained by the vaccinated employee. However, the WSIB, the Workplace Safety Insurance Board, only provides coverage for no-fault injuries. So meaning injuries sustained that were not the fault of the employer. So if put into this context, if the employer made it a requirement for the employee to get a vaccine, and they then became unwell and they can't work due to being unwell from the vaccine, they may not be able to rely on WSIB for pay, since the injury would not be considered potentially as a no-fault injury. The other thing to consider as well is not every workplace falls under WSIA or the Workplace Safety and Insurance Act. So if you're outside of that scope of that legislation, then you're talking about potential civil liability against the actual company who made this vaccination mandatory. It's possible for that civil liability, and that would be something such as negligence. A lawsuit against the employer will be about reasonableness or remoteness of damage. However, it may not be found to be a breach of duty of care if the employer had a bona fide occupational requirement. In such a circumstance, it may be less likely that the employer is found liable as it was a reasonable requirement. One thing to consider here as well is that in a circumstance where someone becomes very unwell from a vaccine, there may be two entities in which the employee or the individual has the opportunity to pursue as a result of this. And it could be the employer, who is the one that made the vaccine mandatory, and it could also be the manufacturer of the vaccine, depending on the circumstances. And out of those two, it may be the case that it would be easier to pursue one's employer versus a large pharmaceutical company. So it's something to be considered in these circumstances.
So I guess employer beware is an easy target. Now, what can you do if an employee refuses to get vaccinated based on a personal preference? Tanya Samby, please take it away.
Thanks, Ron, and good afternoon, everyone. So there's been a lot of debate about whether the vaccines are effective and the potential risks of taking the vaccine. So what if you have an employee who refuses to get vaccinated because they just don't believe in the vaccination and its effectiveness? What can you as an employer do in that case if you want to mandate a required vaccination? So step one is to ensure that the reason for refusal is a personal preference and not a protected ground. So some examples of a personal preference include, I don't believe in vaccinations, or vaccinations will not provide any protection against COVID-19. And actually in a human rights tribunal decision, someone said, it is my belief system to critically evaluate the government's decisions. So these are all examples of some personal preference, and they're not protected grounds under the Human Rights Code. And as Ron mentioned earlier, some of the protected grounds are age, disability, and religion. So if it is a protected ground, like Ron was talking about earlier, then it will trigger a duty to accommodate. But if it's not a protected ground, then there's no need to accommodate the refusal. So if the grounds for refusing are purely a personal preference, then you may wish to educate your employees. So that's step two, educating your employees on the efficacy of the vaccine, the scientific data to support the vaccine, the risks and benefits of getting vaccinated, and also whether the benefits outweigh the risks, and also the protection that the vaccination offers against many variants that are currently going around, like the Delta variant. And of course, all this information should be based on scientific data and credible sources. And step 3 is alternatives to vaccinations. So what happens if you educate them and they still refuse? Well, you can offer some alternatives to getting vaccinated, like continuing to wear a mask, social distancing, working from home, extending the period for the employee to get vaccinated after they've been educated on it, and or reducing their duties so they can work part-time from home, or changing their duties so they can work away from members of the public and other employees. For example, a grocery store cashier may be required to work in the back instead of at the cash register. And of course, reducing duties or reducing working hours to part-time may lead to a constructive dismissal claim. So you should definitely seek the assistance of an employment lawyer before taking this step. Lastly, if alternatives are not an option for your workplace, you can discipline the employee for breaching the mandatory vaccination policy. And that's step 4. Some progressive steps to discipline include a paid leave of absence, a warning, and finally, termination without cause. Now, you can terminate an employee by giving sufficient notice. But remember, employees are entitled to minimum employment standards termination and severance pay, as well as common law, which can exceed 24 months pay. So there is a hefty price to termination without cause. If, however, the employee is refusing on the basis of a human rights ground, you want to be careful about that because it could open you up to a human rights complaint. And you should also be careful when terminating an employee for their refusal to get vaccinated and seek the assistance of an employment lawyer.
Thank you, Tanya Sambi. I guess the key thing there is none of these steps should be taken without seeking advice of an employment lawyer. That's the key thing, because huge potential for liability. Now, the hottest topic we've been asked questions on is, can you require an employee to disclose whether they were vaccinated? That means orally or in written form. The quick and short is only in exceptional circumstances. So what if you don't want to require your employees to be vaccinated, but you feel that this would be an imposition perhaps on your employees' privacy and health rights, but you still want to make sure you're providing a safe workplace? So when deciding when to bring your employees back, can you ask them whether you are vaccinated? Or perhaps you're of the view that you're adamant that you must know because you want to know. So that's what we're going to answer. First thing is, what are the legal considerations? So what is the consequence of asking for disclosure, and what is the purpose? So the consequence, because businesses are grappling with this, how to manage it. There's vaccinated ones, there's unvaccinated ones, with these refusals, vaccination hesitancy, and also medical contraindications. Employers face demands by employees, and what for? Well, privacy complaints. This would be the privacy commissioner. Lawsuits, Ministry of Labor complaints, and for claims of discrimination under human rights legislation. So the first question that an employer must ask is, for what purpose are they inquiring whether an employee has gotten a vaccination or requiring a vaccination certificate? So remember, the employer's duty is to provide a safe workplace. Now, how important is a vaccination to the workplace given their practice of masking or social distancing? And if many workplaces are already vaccinated and masking and social distancing, then why require certain other ones to vaccinate? So these are considerations that must all be looked at in determining what you're going to do. Now, privacy considerations, what are they? There's a joint statement from the Office of the Privacy Commissioner of Canada. And that statement warned that requiring employees to provide proof of vaccination is an encroachment on civil liberties that should be done only after careful consideration. It refers to balancing the company's purpose with an employee's privacy rights and meeting all of the following conditions that require disclosure. And these are meeting the condition of necessity, proportionality, and effectiveness. So in other words, the disclosure necessary, proportionality, that proportionally speaking, the disclosure is required, and that getting the disclosure for some reason is effective. So they say you should be able to establish all those conditions. So what type of workplaces might these criteria be met? Well, one thinks, what about those in close proximity? For example, a production line in a factory who are unable to perform their job from home, and it's impossible to really social distance there. Then you know what? It's possible for the employer to require proof of vaccination there. But of course, that employer should get legal advice because every situation is different, every circumstance is different. Now, what if the employee can work from home or work from the office that maintains social distancing or can maintain it, and especially with limited contact with the public? Well, less likely than they can require proof of vaccination. So what kind of proof could one request? Well, 3 examples: verbal, request a document, request it and copy it. So the key thing is determining what is required, using the least intrusive method, least invasive method. And verbal confirmation obviously is the least invasive. Request a document to look at, not copy. That's second. Third is request a document and keep it, copy it, retain it. That's the most invasive, and one would only want to do that with legal advice, or actually any of these with legal advice. Steps for obtaining disclosure, if you can do it. If you've been advised by a lawyer you can do it, what do you need to do? Number 1, the least invasive method. 2, the least amount of private information be obtained. Number 3, get the written consent. Number 4, explain the use, how it's going to be used, and how it's going to be stored. Maintain confidentiality of that information, and limit use of private information to the intended purposes only. Lastly, share information on a need-to-know basis. So if certain management need to know and have to know, and there's a legitimate reason for their knowing the numbers are vaccinated, then if you can do so without sharing any names, and really there's likely no reason to share names with that stage at that purpose, then you would not want to share names or identify any of the employees. So interesting topic. Moving on to Kyle. Can you enforce mandatory COVID-19 testing? Kyle, take it away.
So with the question, can you enforce mandatory COVID-19 testing? So let's talk about the legal considerations about this first. Employers have a duty under the Occupational Health and Safety Act to protect their workers' health and safety while they're at work. This duty requires employers to take, and as the Act says, to take every precaution reasonable in the circumstances. Mandatory COVID testing has been found to be enforceable in certain health and safety sensitive environments, such as potentially airports, hospitals, and long-term care homes. In these situations, courts and arbitrators have held that such policies of mandatory COVID-19 testing are reasonable and enforceable given the implications of an undetected case or outbreak that can occur at the workplace. You'll see there on the slide that we reference a case, the Carasent Care Nursing and Retirement Homes versus Christian. In this case here, the arbitrator found that the employer's policy about mandatory testing for mandatory testing, that they found it to be reasonable. And this was, and this is the important point, that the policy offered accommodation and alternatives to testing. And as a result, the employer's discipline of an employee's failure to follow the COVID-19 testing policy was justifiable. So those are some of the legal considerations to have or to think about when thinking to put into place mandatory COVID-19 testing. Now, if we want to talk about the steps to implement mandatory COVID-19 testing, if it is something that is able to occur at the workplace or is permitted, there's 2 ways that this can be done: by way of policy or an employment agreement. When it comes to these types of documents, you want to make sure that they're reasonable. And I know that this is sort of echoing another point that Ron had made previously. You want these things to be reasonable in how they're written. And also have different forms of accommodation within them. Going back to that case, that seemed to be an important point in the case about having different forms of accommodation to have that policy being enforceable. And so different types of accommodation that can occur aside from mandatory COVID-19 testing. And I'm sure we're familiar with a lot of these already, the different test options such as throat swabs, non-invasive measures, so doing temperature checks, the masking and social distancing that's been in place for a while now. Having alternate duties, so swapping employees around with alternate duties, sort of a shift idea in that sort of way. And then, of course, there's the continued idea of working from home. This obviously will not be applicable for every single workplace. It's going to be very context specific for every workplace, especially for things like working from home. There's going to be a lot of industries, a lot of businesses that's just not an option for, or that maybe a lot of these aren't options for. But that's some of the different steps to implement it. It's important to note that the Human Rights Tribunal of Ontario says that that the Human Rights Code ground of disability, that it can be engaged when employers impose medical testing. However, medical testing to determine fitness to safely perform work may be permissible under the Human Rights Code if the testing is shown to be effective and necessary in circumstances such as the pandemic. So those are some of the ideas of steps to implement if for mandatory COVID-19 testing.
Good information, Kyle. And it should be noted that this area is evolving. As we speak, it's evolving as to different PPE mechanisms and as to forms of accommodation. These are the ones that are hot right now, ones that are being used. But that's not to say this evening we'll hear on the news other forms of PPE testing. There's also the face shield as well too. And you see, as you go to some different workplaces, sometimes there is plexiglass between people as well. So that's an additional form of really, trying to provide a safe workplace. So, when in analyzing this, you look to see, is there a disability? Is there accommodation? Is it required? And even if there's not, you've got to balance it. So the key thing is a safe workplace versus protection of the employee's privacy and health rights. And that's the balance. So you got to really think here out of the box. Are there other ways to do it? And we see a lot of companies, and especially in Markham and York region, have put up the plexiglass between the workers. And we applaud them for the steps that they're taking. And we've really seen companies really come to the fore, companies that are our clients and not our clients in Markham and abroad the York region, that have really taken all these steps. And that's really to be applauded. So, don't think in the box, think out of the box. Consider, what else can we do to ensure a safe workplace? And there's a lot of great resources out there that companies, innovators that have developed various things that can help your workers and can help ensure that you're ensuring a safe workplace for your employees, and then also balancing it with ensuring that their rights with respect to medical information, their privacy rights are being protected. So some good points. Thanks, Kyle, for that. Now, the issue of working from home versus working from the office, and it'd be interesting to see how many in the audience are not where they were living 2 years ago or working 2 years ago. I wonder if we can trace the IP addresses to see how many are zooming in from maybe Fiji or Brazil or Europe or some other neat country. But we've seen these different things, and so we've had people ask us these questions. These are the most common questions we've been asked. So we thought, let's put this together for yourselves. So working from home versus working from the office, what policies should apply? It's a great question. Tanya?
Thanks, Ron. So starting in March 2020, the majority of workers shifted to working from home. And now that we're well over a year into the pandemic, a lot of workers are still at home, and some actually prefer it because it's just saves time on commute and lets them be at home with their families. So it looks like this may be the new type of normal that we'll be facing. So what kind of policy should an employer have in place given that their employees are working from home? Well, the short answer is all of the policies that they have in place still apply. And so there are 3 required policies that employers have to have. The workplace health and safety policy. And so a way to update this, given that employees are working from home, may be to have clauses regarding ergonomic equipment like an ergonomic chair or keyboard. The workplace violence and harassment is also a required policy. And one particular way you might want to update it, given the work from home arrangement, is that domestic violence may need to be redefined, given that the workplace is now at home. So that might be a consideration to have. Also, given that everything is online now and a lot of people are communicating online a lot more, cyberbullying might also be a concern and might be something you want to put into your policy. Accessibility is also a required policy you may wish to update. So what about some recommended policies? And so these are policies you don't have to have, but it might be a good idea to have them in place. For example, there's a pay equity plan, a drug and alcohol policy. What about social media? So if you did not want your employees to be, browsing through Instagram or Facebook while they're at work, and if you still want them to not do that while they're at home, then you may wish to implement a social media policy, which prohibits the use of social media during core business hours. Human rights is definitely a key policy to have in place. There's also accommodation policies. So when the school shut down and the children were at home and parents had to take care of them and also work at the same time, that was really difficult on a lot of people. And so you may wish to include accommodation for family status by offering flexibility for childcare obligations during core business hours. And mental health is also something that the pandemic really brought to light, and how employees are being burnt out. So again, mental health accommodation might be something to put in your policy. Absenteeism, privacy, and workplace injury are just a couple of other recommended policies. And with respect to workplace injury, as I was mentioning, the workplace now is technically at home. So the definition of a workplace injury may need to be redefined and reassessed in your policies, given that change. Confidentiality is a key policy to have in place, especially when your employees are working from home. So with lawyers, there's a zero tolerance for confidentiality breaches. Confidentiality applies to keeping confidential information away from your spouse or your family or children. So let's say your employee is on a Zoom call with one of your clients and they're discussing confidential information. Can your employees, children, or family members just walk in and out of the room and hear whatever they want to? You probably don't want that. So you may wish to include a requirement in your confidentiality policy to have employees working in a private area with a door that can be locked to prevent people from barging in the middle of confidential Zoom meetings. Speaking of Zoom, there's also a video conferencing protocol you may wish to have in place. So what kind of a dress code do you expect your employees to have when they're on Zoom? Do you want them to dress the same way that they dressed when they were in the office, at least for the top half? What about professionalism? Do you have a specific background that you want them to have? A clean desk, noise control, and again, confidentiality. That's a key thing in this video conferencing protocol. So sick leave and medical leave. What if you have an employee who says, now that they're working from home, they just have a cough or they're not feeling well, so they'll work for a couple hours and maybe take a nap and then just consider the whole day that they worked. You definitely don't want that. You want your employees to still be taking the day off if they're unwell, to be able to properly recuperate and not, just work for a couple of hours. It promotes wellness and prevents burnout. So your sickness and medical leave policies should be updated to incorporate this. Finally, with respect to vacation and overtime policies, you also may want to update this. It's tough to divide work and home life now that work is at home. So you may want to, in order to prevent burnout, require employees to take vacation. Even though they can't travel anywhere, go anywhere because of COVID-19, you still may want to insist that they take this vacation time to prevent burnout. Also, you want to ensure that your employees aren't working an excessive amount of overtime, partially to prevent burnout, but also partially to prevent yourself from dealing with an excessive overtime claim. So you want to try to cap the overtime and ensure that the overtime is only incurred with your discretion. So these are just some of the examples of policies that can be implemented and updated.
Good, thank you, Tanya. So who can believe now that all the policies that you had at your workplace are now applicable at your employees in their homes, each and every one of them? Something, well, I'm sure most didn't think of way back then. And I'm going to have Tanya and Kyle, we jump into assist on this one. We're running very good on time. And I mean, such policies such as violence in the workplace. We see that it there's probably maybe more exposure to the employer with the employer working at home due to domestic violence. And these policies apply at the workplace. So what is the workplace? And have you thought of what that workplace is? And maybe Kyle can help out on this one. Is that workplace the traditional workplace in the office, or where can that extend? What can be considered a workplace? Kyle, you may want to jump in and maybe just get your view as to what else is considered a workplace besides the actual office or factory or business.
Well, yeah, I think it's a question that's now been definitely thrown into the forefront on this, right? And I think that there's definitely arguments that can be made on both sides, that someone's home, if they're now working from home, is or is not the workplace. And I think that, as often happens for a lot of things in the legal world, it's going to come down to the specifics of that circumstance, the specifics of the situation, and to be able to justify it. Sitting here right now, I'm not aware of a decision that's come out that specifically addresses that as of yet. But I can tell you that when the decision comes out, it's something that lawyers will certainly be interested to see and will be wanting to let their clients know about, because the ramifications, depending on which way that decision goes, could be huge for companies. It could be massive, with a lot of concern and drafting that's going to have to happen quickly to make sure that I's are dotted and T's are crossed.
Good, thank you, Kyle. And also with Zoom video conferencing, whoever thought that at your worker's home you can enforce address policy? And we've seen slip-ups. We've watched the news. I don't know whether fellow parliament, I've never had a chance to see what their policy is, or if they have a policy on Zoom, or what should be worn or displayed on Zoom at parliamentary meetings. So you may want to have a policy in place. Tanya, did you want to maybe comment a bit about Zoom professionality and what the employer can expect?
Yeah, so just building off of what Ron just said, so what an employer can expect is you maintain that professionalism that you did in person when you were having meetings with your clients. So if you're required to dress in business formal attire, that same expectation applies to Zoom. If you're expected to have a clean desk and have a clean background, maybe a nice picture in the background to represent the office you're sitting in, again, that might be something that's expected and something an employer can ask you to do. So just sort of mirroring what you previously used to do when you met with clients, and now that we're on Zoom, it's not that different.
Great. And note that when this first happened, March 15th or mid-March of last year, and everyone went home from the office, and we had Zoom meetings, and no one looked like we do today. And that went on for a few months, and now all of us have no choice but to comply with our office policies, which we're all doing. So interesting times. And who would have thought that all your office policies are applicable at home, of course, with some flexibility and also application to that home environment. So great information. So the next topic is, what can you expect from an employee working from home? And the short answer is almost everything as at the regular workplace. So, now that we've reviewed the recommended policies, what can employers expect from their employees who are working at home? Well, no doubt you've got start times and end times, or likely have that. Well, that would still apply. Following, as you heard, all the office policies. Maintaining professionalism during Zoom calls. No slip-ups. They can be devastating or damaging. You got to also watch if you're using the lavalier mic and you need to step away from your computer, that you turn your mic off, because realize the sound's on. So that's gotten some in a little bit of trouble. Also, you can't expect your employees to work 24/7. It's easy. You go from the bedroom to maybe take a break at the coffee machine, and then to the computer, and you're on, and it's easy to work because there's no real time division where, oh, it's time to go home. I'm going to now leave the office or now leave the workplace. So, but you don't want them to work 24/7, because it's not good for them, and that's not good for your productivity. Also, what if there's children around? What happens then? And that's a consideration. So, can we take a hard and fast approach as employers and say, no, here are the core hours and you can't have any distractions? Well, how can you control that? You can try, you can do your best. So it's really important that employers allow for flexibility for childcare, working and also working outside of the core business hours. Some at ourselves, we may be busy with other, personal or home tasks, not all throughout the day, because usually the 8 to 6-ish times when we get most of our phone calls, but there's times we'll be busy with other things, and then we're flexible. Then after the usual time that we stop working as lawyers, who knows when that is, we would then be flexible and maybe a little bit of time off during the day to care for some childcare matters, but then add that time later on in the evening. But you got to be very careful that there's balance there. So you want to follow all policies, expect the employees to maintain confidentiality. That's very, very key. And only expect the same business hours if, though it's key and important to do so. The next point is, what if your employee wishes to work from another province, territory, or country? And we've seen a lot of this. A lot have taken the exodus, and who knows where they are. I think we got an email from Timbuktu. I'm not sure what country that's in, or whether that's a city or what. But people are working out of Prague, out of Fiji and Hawaii and Ukraine, Kawartha, Niagara Lake, and many, many other places, California, Florida. So, what happens then? What do you got to know about if they're in another province, territory, or country? Well, what are the tax considerations, right? Withholdings are provincial and federal. What if they're in a different province or a different country? Could those laws apply to you, your employer, your company? They could. What about different employment standard legislation? Each legislation in the country is different, very similar, but some minor differences. But those minor differences can be very important. The states, it's quite different. Most states operate under employees work at the will of the employer, which is contra to Canada, where in the Supreme Court of Canada and Wallace, Justice Ikabuchi has said that employees are vulnerable. So the laws are much different. What about the Pension Benefits Act? But you never thought of that one. Human rights legislation. How does it differ from province to province and country to country? Workplace Safety Insurance Act considerations, or provincial health care, immigration and citizenship. If they're too long somewhere else, will they lose the citizenship? What if they're on a work permit? What about the occupational health and safety requirements? They would be different in different places, different time zones. I think Tanya looked into this. There are 6 time zones in Canada. I never realized that. It could be a permanent move, then maybe a new employment agreement. The return to work could be considered constructive dismissal if you require that. So a lot of factors, a lot of considerations to look at. So, could your company be bound by, Mexico law? Possible. Could they, if a worker is there, move there, could a worker then, employer be bound by Mexico and Canada and provincial law in Ontario? Well, they may as well too. So you need to exercise caution, great caution, if your employee wishes to work for another province, territory, or country. And that's where you need to get policies. You can't just have individual rules for someone as they approach you. You need ahead of time to go through all these issues that we've discussed today, and I'm sure there's many more. Put your policies in place. But you need to consider, are they reasonable? Maybe Kyle or Tanya, you can jump in here. What are the reasons have you seen for some being able to not comply with policies, or let's say, employers that have set up policies and courts that have not permitted employers to enforce those policies, which means the employee can run afoul of those policies or just tear them up and do what kind of they want to do. Where have you seen circumstances like that? I see Tanya, you've unmuted yourself, so please join us here.
Yeah, so some of the circumstances that we've seen before where courts have said, you know what, you can't discipline someone based on this policy is usually where the employer doesn't actually enforce the policy across the board. So they'll do it sporadically. So whenever they want to enforce the policy, they'll do so. That's usually not okay. Another case is where they haven't clearly communicated the policy, where the employee just doesn't know that this policy exists. And the courts say, well, you can't discipline them for that because how did they know that they weren't supposed to breach it? Or where the employer breaches the policy themselves. So for example, if there's something the employer needs to do pursuant to that policy and then just doesn't do it, that's a case where you can't really enforce it.
Now this one, I think Kyle may want to jump in. We just finished a case, a 3-week trial by Zoom in Barrie Court, and Kyle was the lead counsel on that case. And my role and Tanya's role was assisting on the trial. And that a lot of it was about, policies that were supposedly set up. And, in this case, Kyle may want to jump in to see, what are some of the things that we had said or positions that we took to the court with respect to why those policies wouldn't be upheld.
Well, I think just also being mindful of time here, though, it sort of just goes to what Tanya was saying. A policy is only as good as it's going to be enforced, right? So if a policy is not enforced in some way, it's hard then in the future for an employer to actually rely upon that policy. So it's not just policies, as we said throughout this presentation so far. They have to be reasonable. You have to have accommodation, those sorts of things. It's also, if it's not being enforced, then an employer can likely have a really hard time then trying to enforce it at a later date when it hasn't been followed to date. So
yes, so those are some key points to make sure if you put a policy in place, make sure it's reasonable, and make sure you don't condone breach of it by not complying with it yourself. So Kyle, what are the return to work issues that an employer can expect?
So yeah, no, this is another question that we're getting asked quite a lot now that things are starting to open up, and we're looking at entering into step 3 of the opening up process, or phase 3 on Friday morning. I hope I got that date right, Friday morning. So
it may change, we don't know.
You never know, right? You never know. So this is a question we're getting asked a lot. And so succeed in returning employees to the workplace. There's no set rules on this. Nothing I would say that's carved in stone. Every situation is going to be a bit different. But generally speaking, the key is to be reasonable. So for example, in some circumstances, providing reasonable notice to the employees of the requirement to return to the workplace, ideally doing that in writing versus verbally. The length of notice that would have to be provided will, of course, depend on the circumstances. In some cases, it's going to be a few days. In other cases, it could be longer. It's also best to have a policy in place requiring to return to work as soon as possible. Now, this may not be something that a lot of companies have already because who saw the pandemic coming and people having to work remotely from home? Probably not a lot of individuals, if any, or a lot of companies, if any. And so to have been proactive in putting these policies in place, but it may be something as a takeaway from this that a policy can be put in place if there's ever the requirement, no matter what it is, for someone to work remotely now, especially given that a lot of companies have put into place the foundation for employees to be able to work remotely. But having that policy there, and then you don't want to delay in seeking the employee's return if the policy indicates this. You don't want to have that delay, because if you delay on it in some way, it may not be enforcing a policy, as we were just discussing about, and it may result in the employee actually being able to remain working from home. It's also important to note that some employees may not be able to return immediately, and we've spoken about this a little bit already. There's childcare obligations that some individuals may have, or caring for other family members for COVID related issues, and as a result, employers have a duty to accommodate for this up to undue hardship. some employers are refusing to offer any kind of hybrid model, just asking for all employees to come back and want their employees back as soon as possible. But employees are used to working from home, and for some, it's much better and more convenient for them working from home versus from the office, and not just because of an accommodation issue, but for other reasons. So in fact, some employees may have moved out, as Ron was alluding to. They have moved out from where they were, and the distance that they're from the workplace now could be much greater. And for that reason, either a hybrid situation of working at home and the office, or just working from home, may be a good solution. Again, I want to preface by saying this is not applicable for every single business. It definitely depends upon the industry you're in, the business that you conduct in, and the reality of this for you as a company. But a lot of employment experts have been saying, and I'm sure individuals have seen this in the news as well, that they're anticipating a swarm of resignations once the economy opens up again, and employers start requesting employees all to come back. So the question becomes, how can you keep your employees happy and potentially retain new talent? And again, like I was saying, a hybrid system, if it's possible for your industry and for your business, or the ability just to work from home, but certainly accommodating. One great move on this could be that if you have employees who are asking to work from home, not from an accommodation standpoint, because that's just a duty to accommodate, but if you have employees that are asking to work from home, it may be an opportune time to use that as a way to establish a new employment agreement. During the pandemic, in the middle of 2020, there was a decision that was rendered that changed a lot of employment agreements from likely being valid with respect to termination clauses to being invalid. So there's a lot of companies walking around out there with termination clauses that may not be enforceable. And in order to have a new contract become enforceable, there has to be what's referred to as adequate fresh consideration to establish a new contract. And perhaps this can be used as a way to form a foundation for fresh consideration to update your new contracts, or if you don't have a contract, certainly a way to be able to put one into place. So it's something to consider on that front, as an idea of, if your business can do it, the way that you might be able to put it in your company's favor. Moving on to the next slide, with the mental health considerations. So there will likely be a situation where some individuals just have a fear of returning to work amid COVID-19. Certainly, it's been something that's happened during that we've heard about happening during the pandemic, as places have been opening up. And then in the initial days, when people were sent home just to sort of get their bearings, and then asked to come back for essential workplaces that were allowed to be open with social distancing and masking requirements and so forth. Their individuals can have a fear about returning back to the workplace. When it comes to the right to refuse work for an employee under the Occupational Health and Safety Act, this legislation was drafted to say that the issue is whether the inability to continue to work is due to the physical condition of the workplace. So in a situation where an employee is refusing to come back to work, it may be the best option to just simply ask the employee, why is there a concern to come back? If it's a physical condition of the workplace, then the employer should likely be doing everything they reasonably can do to correct it in the workplace to have the employee come back. Whether it's a physical condition of the workplace or not, the employee may still be suffering from a disability protected under the Human Rights Code. That's the foundation for this fear of coming back. And even if the employee says it's a physical condition and doesn't say that they are suffering from a disability, the laws are written in favor of employees, and a court could simply say, and I'm simplifying things here, but a court could say that you should have known that the employee was suffering from a disability, and that it was a failure to accommodate, being a breach of the Human Rights Code, even though there's no physical condition at the workplace. So in these circumstances where you have an employee or employees refusing to come back to the workplace, definitely it's to your benefit in all likelihood to be cautious and obtain counsel on these points if they come up and when they do. We've talked about, or I've mentioned about the duty to accommodate, and it's to the point of undue hardship, and we've touched upon this already, but briefly, just in this context, So hardship can be expected in order to accommodate an employee. It just can't be undue hardship. And often we get asked the question, well, what's the difference? And it depends on the facts of the case. And a lot of litigation does occur over the question of, was that undue hardship or just hardship that the employer would have to go through? So employers do have a right to inquire as to what accommodation is required and the prognosis. Employers could require the employee to provide a medical note with respect to this. Doctors often advocate for their patients, so you may be able to question the medical note that's received. We often draft letters for our clients to forward to the employee for their doctors, asking specific questions regarding required accommodations. So often accommodation when there is a disability, the accommodation that may often apply could be a gradual return to work, but we'll see how things pan out when it comes down to a fear of returning to the workplace. So, best practice, if an employee says that they're unable to continue or unable to return to the workplace, and you've ruled out the physical condition of the workplace or cannot reasonably comply with changing the workplace, then trying to accommodate them, right? If all else fails, accommodation could also be working remotely, right? Instead of actually having them come back, again, industry and business specific. As long as accommodation proposed by the employer is reasonable, that's what is being required generally under the duty to accommodate. And if employees fail to cooperate with reasonable accommodation proposed by the employer, then the employer has fulfilled their obligation. So the employment relationship may end at that point. And as we've indicated here on the slide, if undue hardship is reached for accommodation and it can't rectify the situation, and the employer is thinking about terminating the relationship as a result, certainly you should be speaking to an employment lawyer about that. There's a lot of things that can stem from it. You could even just have a disagreement that you hit the threshold of undue hardship. And you could be facing not only just how much notice you're going to have to provide an employee, but allegations of breach of human rights and so forth. So certainly getting some legal advice on that before you move forward thinking that you can terminate under the circumstances is wise in those circumstances.
Excellent. Tanya, breach of COVID-19 policies, discipline and terminations.
I think
Kyle, I think you have one more slide left.
Yeah, I got one more slide there. Yeah, I was gonna say.
I'm sorry.
That's okay. That's okay. So do employees who have been vaccinated still need to socially distance and wear masks in the office? This is a question that we get asked as well. And really, it's going to depend on public health measures. So right now in York Region, businesses are still required to have their employees mask if they work in an area that is accessible to members of the public, are not able to maintain 6 feet of distance while indoors. The exemption says the following groups of people are exempt from the mandatory mask requirement, and that would be, if they perform work for the business or organization in an area that is not accessible to members of the public and is able to maintain a physical distance of at least 2 meters from every other person while in the indoor area. So being vaccinated at the moment does not mean, as it currently stands, that you can take your mask off and stop socially distancing and all that at the workplace, but you certainly should pay attention to the public health measures in place.
Great. Tanya, breach of COVID-19 policies, discipline and terminations.
Yeah, so we're mindful that it's 4:30 now, so I'll be quick through this section. But this is the last section before we finish the slide. So what if you have a COVID-19 policy, and like the ones we've been talking about, and your employee breaches it? Can you discipline or can you terminate? So you may be able to discipline for a breach of COVID-19 policy, but it's likely difficult to do so. As we were discussing, you need a policy to be reasonable, consistently enforced, and it cannot be unconscionable or against public policy. So whether you can discipline really depends on the policy and how you've enforced it before. So if the policy is for requiring vaccination, it may be harder to discipline or terminate, particularly because you could be providing accommodation for the refusal, such as PPE and social distancing like we've spoken about. So if you can discipline, some examples include a paid leave of absence and a warning. And now we have suspension crossed out, and that's not an editing error. We intended to do that because we wanted to reinforce the idea that you should not be suspending an employee because this could lead to constructive dismissal. What you should do rather is place them on a paid leave of absence. So suspension should never be a discipline. Now, terminating without cause for breach of COVID-19 policy. We've mentioned this before. You can terminate, you give notice, no reason is required. You do need to provide the notice under the Employment Standards Act and under common law, which can exceed 24 months. So it's best to check if you have a termination clause in your employment agreement before you do so, because this can limit the amount of notice you have to pay to just the Employment Standards Act. And if you don't already have a termination clause in your employment agreement, we recommend you get one because, again, this can significantly limit the amount of notice you have to pay. The best way to do that is to speak to an employment lawyer. It's also best to first investigate any conduct issues and to make sure that there's no grounds for human rights. Because like Kyle was mentioning, if you do terminate and there's a ground for human rights, you can open yourself up to a human rights complaint as well as a wrongful dismissal claim. So you want to remember that any termination should always be done with the advice of an employment lawyer. Now, with termination with cause, this means that you potentially are paying nothing, and in unique circumstances, you're only paying the statutory minimums, which are the Employment Standards Act minimums. So when can you terminate with cause for a breach of for a breach of COVID-19 policies? Well, there are two cases that recently came out. In the case of Garda Security Screening Inc., the arbitrator found just cause, where the employee received a COVID-19 test, reported to work that day, and then was found to have tested positive for COVID-19. The employee lied about not attending work on the same day as her test, and the employee didn't inform her employer that she'd received the test. The employee was found to have breached the COVID-19 policy and was terminated. The arbitrator found that there was just cause because the employee should have known or ought to have known that the requirement to self-isolate after the test was in place. In another case, Acon Construction Group, Inc., the arbitrator held a just cause termination due to a breach of the COVID-19 policy. So in that case, the griever experienced COVID-19 symptoms, including diarrhea and a runny nose, and was instructed on multiple occasions to not report to work until he was cleared by the employer's nurse. The griever showed up to work even though he wasn't cleared and denied exhibiting any symptoms on his screening questionnaire. The arbitrator held that this was a deliberate attempt to circumvent his instructions with total disregard to the risks he posed, and this created a dangerous situation for everyone involved. The arbitrator noted that the griever's deliberate and cavalier attitude toward the COVID-19 safety risks he represented both to his coworkers and in turn to the company's obligations to protect the workplace was unconscionable, unreasonable, and totally unacceptable. And so the termination for cause was upheld. So these are some of the circumstances where it's possible, but again, termination with cause in particular should always be done with the advice of an employment lawyer. And finally, disciplining for off-duty conduct. Can you discipline an employee for behavior that they engage in when they're not at work? Well, sometimes there's a reputational issue or a legal conduct that the employee is engaging in outside of work. So if there's a link between the conduct and the workplace, for example, reputational harm to the workplace, then it's possible you can discipline. With COVID-19, the risk is transmitting the virus. So it's a health and safety risk to other workers. So it needs to be a pretty blatant breach of the policy. In the case where there is a breach, the employer can comment on it and say, have a conversation with the employee and say this conduct cannot be engaged in further, or they could terminate. So if you learn your employee went to a party and got COVID, and then there's a spread in the workplace, if there's a policy in place that prohibits this conduct, then you can terminate. But again, as we were discussing, policies need to be reasonable, consistently applied, and clearly communicated. So again, just disciplining should be done with the advice of an employment lawyer.
Good, thank you. And I see in the chat, I think we've actually answered most of the questions, I think, in our seminar presentation. If not, then contact our office. But are the rules and regulations different in unionized workplaces versus non-unionized workplaces? Well, the Human Rights Code, Human Rights Act, and the Occupational Health and Safety Act applies to everybody, all workplaces in Ontario. The collective agreement may also contain additional things that companies have to abide by. Now, with that, our suggestion is for more information, if there's anything that hasn't been answered, please contact our office. We have very good employer guides on our websites. We have video blogs on LinkedIn. And if you want a copy of the PowerPoint, then email us at contact@minken.com. That's for the PowerPoint, contact@minken.com. And if you know of any association or company that wishes us to speak with them in a similar setting or workshop, then please give them our name. Richard, thank you so much. I'll turn it over to you now.
Thank you, Ron. Thank you, Kyle. Thank you, Tanya, for your presentation today. Just a couple of notes. First of all, I don't know that it's fun to be a manager anymore. This is not going to be a great time, and certainly challenging for an awful lot of managers as they wade their way through all of these things that we've been talking about today. As Ron mentioned, we recorded this session, so you'll be able to see it when you if you come back and go to our markhamboard.com website. There'll be a link to it there under our events side. The other thing that I wanted to just mention, it was touched on, COVID testing. Our arrangement with the provincial government is that we have these COVID test kits, which we will make available to you regardless of how many employees you have, up to 150. They're free. The employee tests themselves with some guidance from someone in your office, and you get the results back in 15 minutes. So if you are in a place where social distancing and the work environment are such that you're concerned about people being close together, these tests are available to you, and you can go again to our website, markhamboard.com, right on the main page, and book access to get the tests, as they are absolutely free. There is also a link on our website on the main page to PPE supplies, which again, one of our speakers mentioned. So there's plastic dividers, masks, gowns, all sorts of different things. And it's a York region-wide supply list. So you can go there and you'll find a list of companies that provide these things, and it tells you through a grid what they provide and which company has access to those that you can get a hold of. Our next event is our September After 4. It will be our first in-person event. The location for that is going to be the FOF dealership in Markham. Keep your eyes open also, because in the next probably 2.5 weeks, you'll be getting a copy of our Business to Business magazine, The Voice. There's some great articles in there, including issues around COVID and how to be reopening your business. It should be on your desk or in your mailbox in the next couple of weeks. Thank you all very much for joining us today. Stay safe and good luck in reopening your businesses.
Thank you.